you so.
I should also extend my greetings to my Lord. Good afternoon, my Lord. It's actually good evening here.
Okay, and we are now yes, we are now streaming live. So we'll start right about now. So good morning, good afternoon. Yeah. Good morning, good afternoon, good evening from wherever you're watching us. You're welcome to another interesting session of the Mediation Hot Seat. And today we have no other person than Mrs. Funmi Roberts on the hot seat. And for those tuning in with us for the first time today, basically what we try to do here is just to have discussions on contemporary issues surrounding mediation. This is not a training, this is just a conversation around mediation, and it's unscripted. And one of the reasons why we keep our questions unscripted is to connect with the essence of mediators, to know why they do what they do. So thank you so much. So Abby, would you do us the honors of starting off by reading Mrs. Roberts' profile?
Yes.
Thank you so much.
Mrs. Olufunmilayo Roberts, LLM, CArb, FCIArb, FNICarb, is a legal luminary, an astute arbitrator and mediator. She is the founder of a legal and ADR law firm in Nigeria, Funmi Roberts & Co. She is also the founder of Funmi Roberts & Co. Nominees Limited, a company that offers cutting-edge company secretarial services to several blue-chip companies in Nigeria. She is an astute leader with an outstanding track record in mobilizing for corporate and public sector reform with excellent communication and interpersonal skills. She is a chartered arbitrator of the Chartered Institute of Arbitrators UK, a fellow of the Nigerian Chartered Institute of Arbitrators, and of the Institute of Construction Industry Arbitrators, FCIArb. She is a member of the Global Panel of Mediators for the Center of Effective Dispute Resolution, CEDA UK, and tutor, as well as an assessor of both the Chartered Institute of Arbitrators UK and CEDA UK. She is a member of the Arbitral Women Arbitration Committee of International Bar Association, London Court of International Arbitration, Guild of Adjudicators of Nigeria, co-chairman of the Lagos Chambers of Commerce International Arbitration Center. She received global recognition for her dispute resolution expertise when she was appointed as a member of the International Chambers of Commerce Arbitration and ADR Commission. She was recently reappointed to the Dispute Resolution Panel of the NERC, which is the Nigerian Electricity Regulatory Commission, and also is a member of the panel of neutrals of several multi-door courthouses, the Kigali Center for International Arbitration, Rwanda, and the Nairobi Center for International Arbitration. She is with us on the hot seat today. Thank you so much for doing this.
This is her first experience of being on a hot seat. So
you are more than able.
Trepidations.
You are more than able.
Yeah, thank you very much indeed for the invitation.
Thank you so very much, man. And so we're going to kickstart like we always do to look at your journey into ADR, because we're aware that, and we know you wear so many hats. So for the purpose of this discussion, we're just going to look at the hat of the arbitrator and the mediator that you put on. So can you please tell us about your journey into arbitration and mediation, and how you found out about, especially mediation? How did you find out about mediation? Thank you.
Interestingly, I wasn't even looking out to be a mediator. I'd never heard about mediation before until my path just crossed it. In 1990, I was invited by the USIS in Nigeria to attend a program in the US with a couple of other Nigerian women from all over Africa. And it's called Women in the Political Process. We're in the US, taking around the US for about 2 weeks. And in the course of it, we visited a court in Washington. And we're talking about multi-door courthouses. And I asked them, what does this mean? And it was explained to me. And incidentally, one of them mentioned Negotiation and Conflict Management Group, which had just started in Nigeria. So I got the contact details of Mr. Kainde, I know, who, let's give kudos to whom it is. I always call him the father of mediation in Nigeria. Got his contact details, got in touch with him when I got to Nigeria, and I started working with him in NCMG. And my story, my journey into arbitration came much later. I'd been in mediation, and it was very tough to start with, like Milord will tell you, because she then joined us later to promote a mediation in Nigeria. It was very, very tough because it was a new concept, and most of the resistance came from legal practitioners. And I saw myself writing articles to encourage legal practitioners because most of them couldn't see their fees in mediation. So their first line of resistance is, what is this about? And we took several articles, several platforms, offered conferences, seminars, and we didn't have the opportunity of the global platform which the pandemic has foisted on us. So you could see us travel from different parts of the country. And then some of the courses we are doing here in Nigeria, we had to travel abroad to do those courses. So that's how I found myself in it, and I have not looked back since then.
Oh, thank you. Now, I think you're in a better position to critically analyze some of these issues. Now, aside from the issue of fees, let's look at it from two perspectives. First, perspective of lawyers. Why do you think lawyers are antagonistic of mediation? Is it from the position of them not seeing mediation for its full benefits, or it has to do with the fact that they don't really know how to make use of the process? Because anytime this discussion comes up, it's always, first of all, about the lawyers, about them not appreciating the process. What are your thoughts on this?
I always say that in Nigeria, our clients see us as a fountain of knowledge, and they rely on our advice. You would hardly see a client go against the advice given by a client, given by his solicitor. Now, if the solicitor himself does not understand the process, does not appreciate, and has no exposure to it. Right now, mediation is being taught in schools. You have ADR societies in practically all universities. My generation, and probably some people in your generation, had no exposure. So it's like anything new. You first of all look at it with suspicion until you begin to see it evolve and you begin to appreciate the benefits. And that benefit had to be imposed. And that's why we'd be eternally grateful to Lagos State for the first multi-door courthouse in Nigeria, because it was a springboard for mediation. When judges began to refer cases, even some judges couldn't understand it for a while. And I can recall several conversations with the judges, the CJ, to try to convince them about the benefits of mediation. And then the Lagos Settlement Week started. And then the results wowed many people. You can imagine a case that had been in court with the vice president of Nigeria, former vice president of Nigeria, being a party to that case. I've been in court for more than 20 years, went for mediation and settled in one day. And that practically spoke volumes to many people. So I wouldn't say that the lawyers didn't want to do it, because right now, most of them see it. I recall a transaction I had in my law firm, and on the opposite side was a senior counsel from one of the topmost law firms in Nigeria. And I insisted on a multi-layered dispute resolution clause and it was an international agreement. And he was so adamant, Mrs. Roberts, we are not going to put mediation. What is the benefit of the mediation? It's going to add additional cost for the clients. And so it took me a long while to convince him, but I stuck my ground. And about 3-4 months ago, he was taking a class in LASIAC on how to draft transactional documents in international commercial spaces. And I heard him promote mediation. And I had to take him on. Now, sir, you are the one promoting. He said, Mrs. Roberts, I'm now totally convinced. I'm now into mediation. So for me, that kind of testimony speaks volume about the fact that what we're doing, the space we're occupying, would take center stage. There's nobody talking about the reform of the civil justice system now without that conversation going into mediation and the non-adversarial dispute resolution space.
Thank you so much. Then another thing is that most people refer to mediation as the poor cousin of arbitration. Now, and mediation, arbitration, conciliation, negotiation, they all fall under the ambit of ADR. So, in your opinion,
but
why?
let me say this. Some people would disagree with you about that.
I disagree with it too.
Okay, well, if you go to ICC, for example, ICC sliced mediation separately from ADR. So anything that is not litigation, that is not boxed into arbitration is ADR. But some school of thoughts are of the opinion that arbitration and mediation fall. Oh, I can see one of our senior
today's our lucky day, yes.
It is indeed. Mr. Bolaji Ayori, Chief Bolaji Ayori, the senior advocate of Nigeria. It's good to see you. I know he's not in the country. He's on vacation. So it's for you to make time to join us. I'm very, very glad to see you, sir.
Truly honored, sir.
So
Thank you so
go back
much.
to the point I'm making. Thank you very much, sir. Some people see arbitration as a standalone, just like litigation, and then everything else is ADR. But my personal opinion is anything that is not litigation is alternative, because when we say ADR, what are we talking about? We are talking about alternatives to litigation. But they said no, arbitration is a non-adversarial, one party wins, one party loses. I said so are other so-called ADR dispute resolution mechanisms. So I just said to quickly jump in on that so that the young ones amongst us don't go away with the understanding that there's a universal conception that arbitration and ADR are boxed together. So they actually are not, depending on the institution.
So if I'm going to start off on the premise of what you just said now, but why is mediation nowhere in terms of the fees? Because at the end of in terms of the fees to arbitration, and why do you think, in your own opinion, has not been able to take its pride of place as far as dispute resolution is concerned? Now, I don't have a problem with the fact that mediation is not there yet, but why is that people don't first of all see it as the first port of call in trying to resolve disputes before going to arbitration? Because the ultimate dream I look forward to in a not too distant future is to have this tripartite system of starting off with negotiation. If negotiation fails, we'll move to mediation. If mediation doesn't work out right, then ultimately we'll now look at arbitration. But people just want to just bypass the process and go straight to arbitration. So when it comes to everything, why is mediation nowhere near arbitration, in your own personal opinion now?
There are some historical issues raised by you. Arbitration has been in existence long before mediation. Mediation is a new entrant. If you go back and ask people like Stewart Boyd, that how was it when you started talking about arbitration, they'll tell you that they had a lot of resistance as well, because litigation was what everybody was into. But then if you look at mediation, mediation is seen as less tedious, even though I don't agree with that, and takes less time than arbitration. You can be in an arbitration for 2, 3, 4 years. So don't let us get the erroneous impression that, oh, you go into arbitration 6 months, you are out of it. No, sometimes you can be in an arbitral matter for several years. Now, if you look at mediation, by the time you spend a week with the parties and they're not settling, you're out of it, you've exited it. So when you're now talking about fees, it's very difficult for you to convince anybody to pay you the same amount that you pay an arbitrator. But what I have done, and that's what I tell to many counsel, is that when I feel that there's the resistance to mediation, sometimes I do it for free. And I can see situations, I can tell you of several situations where I have done free mediation and the parties have come back to me with other disputes and sometimes counsel. This is a new phenomenon, and it's like we are pioneers. And if you go to any pioneering space, they will tell you that they had to make a lot of sacrifices. Believe me, the narrative is going to change in another 10 years. When the students in the ADR societies in our universities take center stage and are the ones in the dispute resolution space, they are not going to follow the same path. But having said that, let me also say this. Some of these issues boil down to how we draft our dispute resolution clauses. If we want to make rain as lawyers, we have to draft our dispute resolution clauses in a manner that provides that rain. Now, how do I mean? When you have a dispute resolution clause in your agreement and you say, if parties negotiate, they can't agree, they go straight to arbitration. It's a contractual obligation. You can't introduce mediation unless both parties agree to it. But now let us situate it in a context where you have multi-layered dispute resolution clause. If negotiation doesn't work, you go for arbitration, mediation. And you could only go to arbitration if mediation fails. It's in your contract. So parties don't have a choice. And if they go to arbitration, it is the responsibility of practically the respondent in all cases to say that, no, we didn't go for mediation. And I personally, last year, had to send parties to mediation when I was appointed as arbitrator. And what happened in that case was very, very, very interesting. There were about 8 issues for determination. And at the preliminary meeting, I saw the arbitration clause. And I said, well, there's a mediation clause here. And the respondent said, yes, we've tried to bring that to the attention of the claimant, but the claimant said, no. I said, you have to go, because if I give you an award now, one of the grounds for which you would ask for that award to be set aside is that due process was not followed. So they went for mediation. I had to introduce a mediator to them, and they paid very well for that mediation because the claims were quite large. And they were left with only 2 issues they couldn't settle during the mediation, and were told to go back. I was the sole arbitrator, and they brought that back to arbitration. And before we finished the hearing, the parties have settled even those 2 issues. So I think that we need to be more creative in the way we approach some of these things. Even when parties don't settle fully in arbitration, in mediation, I still spoke to some parties that I'd had a mediation with in January. I spoke to them last week to find out, because what I tell them to do is continue talking, and I'll engage with you if I have the opportunity. And it just occurred to me that let me find out. I said, oh, Ms. Roberts, we are still talking. We still have just one more issue to resolve. I have absolutely no doubt in my mind that they will settle that one funny issue and then come back to me. I said, anytime you're ready, I would look at the terms of settlement. It's an LMDC case. I'll look at the terms of settlement with you and you can file it.
Thank you so much. I'm actually laughing out loud because the learned Silk, Mr. Sheni Adio, posted a comment. He said, as part of educating our clients, with all due respect, and indeed the business community, one recurring misconception is that mediation is not binding. And I'm actually happy you brought this up, because this is actually going to take me to the realms of this misconception of mediation not being binding, and the issue of mediation and drafting. So I would like to know, hear your thoughts on what the learned Silk said before I ask my next question on the misconception of the non-bindingness of mediation. Where do you think this came from, ma'am?
It's something that still boils down to awareness. And believe me, I can assure you that unless parties go to an institution like LMDC or CEDA, many people believe that mediation is not binding. A learned Silk, somebody I respect very much, and I were trying to help a company with resolving a dispute between the two founders. And some of the directors acted as mediators because they knew, and then we were putting the agreement together. And at the end of the day, we came up with a mediated settlement agreement. But because that agreement was not, that mediation was not done under institutional rules, Learned Silk thought that it was not going to be enforceable. I then put a call through to Mrs. Yinka Aroye, where I said, look, if we agree outside the Lagos Multi-Door Courthouse rules, can we bring that agreement to you for registration? And then it goes before the ADR judge and it becomes enforceable like any judgment. And she said, yes. All you need to do is to pay some fees. And that was one instance. So when I joined, when the Oyo State Multi-Door Courthouse was created, I'm a member of the governing board. One of the things we did was to ensure that wherever whether you come to the Oyo State Multi-Door Courthouse or you go to any multi-door courthouse or you sit in your office or you sit in your home and there is a mediated settlement agreement, you can bring it to the Oyo State Multi-Door Courthouse. You will just pay, I think, 20,000 Naira. And then the ADR judge would invite the parties and confirm that this agreement was as a result of the conversations they've had. And then she signs it and it becomes binding. But if you don't know, and that is why I keep saying that it all boils down to the fact that we must keep educating people. Even mediators, some mediators don't know that the mediated settlement agreement that they do outside the institution can be taken to the institutions for registration, and then it becomes binding on the parties once it has been registered as consent judgment by the ADR judge.
Thank you. Now, there's another issue that comes to mind, and that I would like to call it ethical issues surrounding mediation. Now, unlike arbitration, where you go through a lot of training, where you just can't become an arbitrator and just start having arbitration cases, mediation is slightly different. We don't exactly have enabling laws per se surrounding mediation. When somebody goes for a mediation training, he or she automatically believes that, oh, I've had this training, I'm a mediator. So now, as mediation takes its place as one of the preferred means of dispute resolution in the not too distant future, what are your thoughts surrounding the fact that we don't exactly have enabling laws surrounding mediation? Anyone can just wake up tomorrow and say, okay, fine, he's a mediator, and he starts mediating or sets up an organization to start training on mediation. As a member of governing councils and all of that, what are your thoughts on this?
The same thing goes for arbitration. You don't have to be trained before you are appointed as an arbitrator. And I'll share something that we say in that space, that you take your arbitrator as you find him. You can appoint anybody as your arbitrator. If that person messes up your reference, then so too bad. Training is not compulsory in the arbitration space. Neither is it compulsory in the mediation space. If we go back to cultural issues and we begin to talk about mediation, the village head mediates all the time, even as we speak. It doesn't have any formal training. So there's nothing that says that you must have formal training, unless, of course, you don't want to be a member of any institution. Chartered Institute of Arbitrators is not going to admit you as a member if you don't do their trainings because of the standards they want to promote. But there is no obligation on you to appoint somebody who has undergone training. It has the advantages because then you're appointing somebody who knows his onions, unlike somebody you just pick because he's a lawyer. I have sat on arbitral panels with lawyers who have no clue about arbitration, and I spend most of the time teaching them, and most of the time arguing with them that no, we can't do it this way. I've sat with Supreme Court judges who think that arbitration and litigation are the same. And believe me, I don't enjoy sitting with them. But some of them have done what late Justice Kayode Esho did. And I learned mediation at the feet of a master, and that's in the person of late Honorable Justice Kaudesho, because he introduced me to arbitration, and I was his registrar throughout his lifetime as an arbitrator before he died. Justice Kaudesho went back to school after he retired from the Supreme Court. And when he was going to be given the fellowship, he said no, he wanted to do some of the courses, and he actually did. But you find some of our retired judges who have refused to do that. And they sit on the panel with you, and you find yourself arguing with them all the time. Sir, we can't do it this way. This is the implication of doing it this way. So I mean, some of them are so good, they'll listen to you, and because they understand the limitations of their arbitral practice. But some of them would say no. And of course, you have to have the courage of your convictions and stick with what you know. And what am I saying? What will distinguish you from the next person is the training you've had. But that training is not compulsory. But I would not urge anybody to start mediating or start arbitrating without some form of training. Now, when you talk about ethical issues, you find, I always laugh when people bring up the fact that, there are codes of conduct and ethical guidelines for arbitrators. You find it in mediation as well. CEDA, for example, has a code of conduct for its mediators. The American Bar Association recently changed its rules, not even recently, as far back as 2005, to bring in rules that would take care of lawyers acting as mediators. And then because there are different expectations from when you're a lawyer and when you are put on the hat of a mediator. But then some of these ethical issues are not standardized because of the multi and interdisciplinary nature of mediation and the type of disputes we mediate on. You can mediate on a family dispute today. Tomorrow you are mediating on a commercial dispute. The issues, there are some fundamental principles. For example, neutrality, confidentiality. We all know all these rules. But the problem is not with knowing the rules and those principles, it's the application. And sometimes the application is dependent on whether the type of mediation you are doing. Is it facilitative mediation or evaluative mediation? Because if you are dealing with evaluative mediation, there's a lot more responsibility on you in terms of ethics. How far should you push the parties? Because remember that even for evaluative mediation, you are supposed to allow the parties to determine the outcome of the dispute. But you test their opinion, you test their the position of both of the parties. But in doing that test, the question is, how far should you go without telling them this is what you need to do? But there is no universal answer to that. If you look at what we have CEDA, we have the European Union regulation, which is based on the US standards for mediators. And you'll find that there is no common agreement on how those principles should be applied. And it is difficult. And that is why sometimes I say that even in arbitration where you have IBA code of conduct, IBA guidelines of conflict of interest, the way I would interpret it is different from the way Alade would interpret some of the provisions. And that is why you find seasoned arbitrators still getting into problems of conflict, of ethical issues. And I would like to say that for the Chartered Institute of Arbitrators Conference, which is taking place in November, I am working with Dr. Tunde Ajibade, SCN, to put the faculty together. We have a whole session talking about ethics in arbitration. It is very topical in view of Halliburton and all those recent decisions. So these are not straight-jacketed ethical principles that you can box into, or this is how you should behave when it is a family mediation. I sit as a mediator in some family disputes and I'm cringing. And I know what I want to say. I know that, look, if we do it this way, I think it's better for the parties, but you can't. And then when you do, sometimes the parties would ask you, What do you, and it happens a lot in Nigeria, what should we do? And the tendency is for you to jump in and tell them, this is what I think you should do. But with skills, with acquisition of experience, you're able to, without telling them what to do, steer them. And of course, if they are listening to you and they respect you, I mean, they would listen to you. So the issue of ethics, we can have another 2-3 hours discussing the issue of ethics. It's a very wide topic. And I invite you all to please register for the Chartered Institute of Arbitrators Conference, and you would meet people who have experienced these issues and they'll share their experiences with you.
Thank you so much, Ma. That was actually one of my first questions. I was going to ask you, what your position was on etiquette and ethics. So you've talked about the ethics, and I know it's something that we could do a whole seminar on. But November, I will register. I will definitely register for November. What about etiquette in mediation?
Etiquette. Well, how do you mean? Let's have a common understanding of what you mean by etiquette.
Okay, so etiquette in the sense of how the mediator relating to parties and handling of the mediation session.
I still don't quite get the point you're making, but if you look at all the codes of conduct of mediation institutions, I know CEDA has it. One of the things you are committed to doing is the integrity of the process, the arbitral of the mediation process. But you can only give what you have. If you don't understand that process, if you have not grounded yourself in knowledge of how mediation works, the likelihood is that you'll mess up the mediation. So if in terms of etiquette, you're talking about how you as a mediator would handle the mediation process, remember that even in mediation, what you are taught, for example, what we teach in CEDA is the safe model. But how you apply that safe model depends on the circumstances of each case. And I'll give you an example. There was a mediation that I did, and the parties refused to be in the same room. I mean, it was such a toxic situation that I had to take one of the parties in my office, and the other one was in Premier Hotel, which is about 5-10 minutes away from my office. He came all the way from Lagos and refused to see the other party. And you'll see me shuttle between my office, and this was before Zoom.
ODR. Well, before Zoom, yeah, not ODR.
And you see, I would move between my office and Premier Hotel. And it took about 5 hours into the mediation before they both agreed to meet. We didn't settle that day, but we settled the following day. And what am I saying? That sometimes you have to be creative. You can have a party who tells you, I don't believe in ODR. I want us to meet one-on-one. You can be in an institutional mediation where they don't even have the type of rooms you expect. You expect a room for a plenary, you expect a private room for one party and another private, but they don't have the facility. If you go to Citizens Mediation Center, I don't know whether it has improved now, but when they first started and I was working with them, they just give you a cubicle. All the parties are outside.
And we have improved, man. That's where I work with. We have improved. We have mediation rooms now.
Exactly. Which is a great improvement. In those days, the parties are outside under a tree. You go outside and bring them in. And you are all in one cubicle. That's why, Abby, I said that it's been a very, very long journey. So if you've moved, you've upskilled, that means that arbitration is eventually getting mediation is getting the recognition it deserves. I don't know whether you understand what I'm saying. So
yes,
you need
yes,
to be creative and don't box your, okay, the last mediation I did before I traveled out of the country, I had 3 meetings with the parties. It was a mediation that could have settled within that day, but then they had to go to their board. One of the companies had to go to their board for approval. The day before I was traveling, they told me that, oh, the board had given approval. Now, go and prepare terms of settlement. Let counsel prepare. When I get to London, I will hold a Zoom meeting. So we've transited from physical to Zoom, and then we look at it together. And when we finish, when you sign, when I come back, I will go, and then we go back to physical. So what I'm saying in essence is you need to be creative, but make sure that the structure you hope to adopt with the parties is something you can handle. You don't want to promise them that you're going to look at the agreement with them when you are unable to share your screen and make necessary adjustments to that agreement. You don't want to promise them that when you come back, oh, I will sign when you're going to be away for 3 months. I offered electronic signature. The party said they don't know how to do it. They prefer physical signatures. I said, well, that can wait 3 weeks. So you need to respect the parties and what they want, but at the same time, be aware of your competence. That is critical, and don't offer things that you are in the Zoom and somebody is behind you trying to help you to log in, and they're saying that, hey, guy, you are breaching confidentiality. So you really need to be well-grounded, and that is why I say that seize any opportunity to learn. Seize any and every opportunity. I can see Mrs. Mujisola Rufai. We're in this journey from the beginning. I'm glad to see you, ma'am. And
glad to see you too, Fumi. How are you doing?
I'm good. I'm very good. We were all in multi-door quarters, NCMG together. It was but it's really great to see you, ma'am.
Thank God for everything.
That answered your question, Abby.
Yes, ma'am. Yes, thank you so much. With regards to culture and culture in mediation, what would you say about the effect of culture in mediation? And then my other question is, how have you found mediation, and how have you found balancing being a mediator and being female? Do you think there are issues? Have you ever faced any issues as a female mediator?
Okay, thank you very much. I incidentally granted an interview with CEDA, and your second question was one of the questions I was asked, and I'll deal with that. Now, when you talk about culture, is there anywhere you can mediate and not take significant, and I use the word significant, in the context of this conversation? Because there are cultural practices that are negative, there are some that are positive. Now, and I'll share just one example of what I did at a mediation. It was an Hausa guy and a Yoruba guy, and they were very, very opposed to mediation. And this was in the early days of mediation at the multi-door courthouse. And what did I do? When I was going, I bought kola nuts, I bought orubo, and I bought just a few bits and pieces. And at the opening ceremony, I offered it to the parties, and the elder, who is the eldest amongst them, who says, can you bless this for us? And believe me, it just toned down the acrimonious. I mean, we spent the first 5 minutes talking about kola nuts and orobo. I don't know the English name for orobo, pardon me. And then, oh, Mrs. Robert, when next year, can you please bring alligator pepper? And we talked about the benefits of alligator pepper. And you could see the parties begin, no, we Yorubas prefer kola nut. And that was what we spent the first 5 minutes talking about. By the time I called them and said, now, can we now go to why we were here? I had broken the tensions between the parties. And what did I use? Something that is of significant, cultural significance to the Hausa guy. And what is of cultural significance to the Yoruba guys. You would use any tool that you think would work. When I joined CEDA faculty to train, one of the things you are taught is that you must use facial contact, eye contact with the parties. I had to tell them that, no, it is not African. And that in Africa, if you are talking to somebody older than you and you are looking them in the eye, it is rude. They were shocked when I pointed it out to them. And that is why whenever they are going to any African country, they invite me along as a member of the faculty so that I can tell them and so if it's a country that I don't know, I'll find out from a friend, look for a friend in that country who tells me about the cultural practices that may impact on that training. And the same goes for anything we do. In mediation, if I see an elderly person, no matter what you tell me, I'm not going to look them in the eye. And when I come into the room, I can't see. Even though, because some of them expect you to sit like a judge. I tell them I'm not a judge. So when I kneel down, there was an 80-something year, I knelt on my 2 knees. Despite the fact that I was the mediator. I didn't know it was that old until he was brought in with it. This is older. I jumped on my knees and knelt down for him. And he prayed for me. So yes, I don't want you see, you need to use what you have. That's the beauty of mediation. Use what you have and just look at your life, your lifestyle, the way you were brought up and see what in the particular circumstances of this case would impact and would help you to get the results that you want.
Okay, now, so
yes, go on.
No, let me let you finish. I'm just blown away by some things you just said.
Okay, let's talk about whether mediating and being female. I've not had any issues in that regard. Perhaps because I started mediation at the floor when it came to Nigeria. And I'm at an age when people forget the fact that I'm female. They just treat me as female robots, which is fine for me. I have not seen it as an impediment. And I don't think that the way it is perceived, the gender issues, because when CEDA interviewed me on this, and then this was a topic, James South told me that it is a real big issue because some people will say that, no, I don't want a female mediator.
Not a female.
But I've not had that experience. Perhaps before I was appointed, it may have been, maybe I missed out on some appointments because I'm female, I don't know, because then nobody's going to tell me that, oh, they said they didn't want a female mediator. It's just that you were not appointed and they won't tell me in any case until I get that appointment. But I've also found that there is strength in being a female mediator. And that is what I can't say it enough that you have to use the skills that are inbuilt. We've trained people who could not hack it as mediators. And we tell them, you just don't have what it takes. Unlike arbitrator, you can read the books and just follow the rules and you are arbitrating. But for mediation, you need there are some skills that you need. And if they are not there, you will fail. There was a retired judge who was talking to me and she said she wanted to go, she's a very close friend of mine. She wanted to train as a mediator. I told her she shouldn't. And I gave her the reasons why she would not make a great mediator. She wasn't happy. 2 days along the line, she called me and said, "Fumi, I think you're right." I said, "Go and do mediation, arbitration. You can't hack it as a mediator. Even as I'm talking to you, you're arguing with me. You are telling me why you'll make a good mediator. I don't know. It's not been an impediment, at least one impediment for me. We need Auntie Moji to mute her microphone. Yes, I mean it takes experience. Oh, that's what people want. There was an arbitration mediation that I did. I got there only to find out that the MD and the chairman of the company are very good friends of mine. And I told them that, look, I know him very well, but I didn't know the name of his company. I didn't know that he's chairman of this company. I disclosed that immediately. And I turned to the claimant and said, are you still comfortable with me going on? And he said, Mrs. Roberts, you come so highly recommended that there's no way we're going to turn you down because you know the MD and the chairman of the company. So my experience is nil in that regard.
Okay, thank you so much, Ma. So now my next question, you actually kind of touched on it. Qualities of a mediator. Now, I know at times it seems like it's a mundane question, but I would like to hear from you, Ma. If you can tell a former judge, a retired judge, I would like for everyone here to hear, because I've had conversations back and forth with, mediators, colleagues on how mediators are not born, whether mediators are born or made. So I would really appreciate your input on that, ma'am.
Now, when we teach, let me go back to, and I'm eternally grateful for the opportunity that I have to train with CEDA, because there are some training, you have to do TOT with them before you can be one of their trainees, tutors. And one of the things that they will tell you on the first day is that we are not teaching you skills you already don't have. What the training does is to bring out those skills so that you can maximize the potentials of those skills in the dispute resolution space. That is all that training is doing for you. And that is why then do people fail? Because those skills are not there. Some people, you help them to bring it out. And let me share an example. I'll keep using the examples of judges. We trained some judges in Lagos State. And I just kept noticing a particular female judge that when she is with her colleagues during lunch, she was so vivacious, she was talking, she was such a pleasant woman. But when we got to the training, she clamped down. And she was so formally dressed in a suit, and as if she was going to court. So I had a side conversation with her. I said, ma'am, can you, when you're coming tomorrow, come in a pair of slacks and a t-shirt, and don't put on, don't bond your hair together. I told her that, look, the Mrs. So-and-so that I see during lunch is totally different from the Mrs. So-and-so I see when we start the classes. I just want you to be yourself. Let me see you in class, the you that I see during lunch. Let me see the you when we go for the formal sessions. Abby, it is unbelievable.
Transformation.
From A to Z. The transformation was phenomenal. And at the end of the training, she passed. And she came to me, Mrs. Roberts, when you said I should not dress so formally, she got home and she started thinking about it. What is the important? Why is it important for her dressing? What is the impact? I said, because you are still dressed as a judge. No, you're not coming here to judge. You're coming here to mediate and to listen and not be judgmental. Your dressing can have a psychological effect on you. And that is why when I'm going for mediations at times, I dress down. When I'm going for arbitration, I dress in a way that you expect a judge to dress. So when you say whether mediators are made or not, if you don't have great interpersonal skills, if you scare people off in the way you speak to them, if you are not warm, parties will pick it up. If you are there and you are shouting at them, this is the way you should do it, then, I mean, there are some things that you just don't have. My friend didn't have it. And at the end of the day, she agreed with me that she didn't have it. So whether they are born or not, I wouldn't know about that, but I do certainly know that all we're doing is telling you to bring out what is already in you. And let me also share something personal with you, because in this kind of interviews, I always say that if you are not prepared to talk about your life, then don't do it. I was 14 years at the bar when I was offered a seat on the bench. In those days, you are invited to the bench. There were no examinations, there were no interviews, no, you were invited. And I said to myself that, Fumi, can you live the life of a judge? I did serious introspections, critical self-analysis. I'd read Lord Denning's autobiography since I was in Ife, and I knew the kind of lifestyle he led, more or less like a recluse. That is not Fumi Roberts. I'm a people's person. I want to have parties and have 1,000 people in my parties. I want to, go to parties and dance the way I am. But if I am a judge, I would not be able to live that kind of lifestyle. I would want to live the lifestyle that I expect a judge to live, and I would be miserable because that is not me.
So to thine own self be true.
To thyself be true. So it's not everybody that can, if you fail mediation courses, because you pay for CEDA courses almost £5,000, and people do fail. People do fail. And because they just don't have the skills. And some of them would have been mediating. Yes, you have been mediating, but how have you been doing it? And are you getting the desired results? Our parties, what's the feedback? Because sometimes we do these things and we don't ask for feedback. I have a personal feedback form for the mediations that I do. I give it to the parties so that I know how I need, what are the areas, and it's something I'll recommend to everybody. Go and develop your personal feedback. So if you go to the institution would give the parties a form. But for myself, I have my personal feedback that I share with the parties and tell them to be truthful to me or with me.
Yeah, thank you so much. Now, is there a general theme? Is there
Sorry, I see that my internet connectivity is very poor.
Okay, no, but we can actually hear you loud and clear from here.
Yes. Okay.
It's okay from my end, yes. Now, is there a general theme that runs through a lot of the cases you've had to mediate upon? And I'm going to, this has to do with the issue of miscommunication and ego. How have they been? How have you seen them come up in some of the cases that you have handled so far? That's why miscommunication, or rather communication and ego. I'd like to hear your thoughts on this.
I laugh because it's something that you come across more here than in some other countries. Have you ever had the chairman of a bank attend a mediation?
No.
Have you ever had the CEO of a bank or of a multinational attend a mediation?
Not yet.
Not yet. Not yet. That's a better answer. Not yet.
Not yet. They hardly would. And it creates a problem for us. And I'll share with you an experience with one of the largest mediations this country has ever had. It is one of the parastatals of the federal government. They had so many ex-staff they had laid off. Some of them had been in court. There are class actions against governments, the groups themselves, there are about 900 and something of them. So a panel was set up, mediation panel, as recommended by the council representing the federal government entity. and I had to administer that mediation. You can imagine a mediation of about 900 and something people. So the administrative part took about 3 months, inviting them, doing spreadsheets, who is counsel for this and so on. It was a mediation we did over a course of almost 1 year.
Wow.
And some we were able to deal with dispatch. But many we couldn't deal with because the mandate from the federal government was don't go beyond this level. But we were of the opinion that there was some that we needed to go beyond that level. And we had written several letters to the PS, the minister, all ignored until we said, no, we're not going to continue without, at the very minimum, the permanent secretary joining us. We did it at the Regional Center for International Commercial Arbitration when they were still in Falomo. So they sent a team from Abuja led by the PS. And within the space of a few hours, we were able to deal with about 30-something of those cases and got immediate results. I was telling you about a mediation that I did that they had to go to the board. If you had asked the chairman of the board to even be at the other end of a phone call, ego would kick in. But then you have to manage the situation. That is where experience comes in. One of the things you are taught in mediation is authority to settle. You're going to ask the parties at the opening, do you have authority to settle? And some of them will say yes, but midway down the line, they'll tell you that actually I had authority up to a certain level, I have to go back. Now you booked a one-day mediation. Are you going to say that you won't give them another? You will give them that opportunity to come back. Because the last one I talked about was supposed to be booked for 1 day. We've done 3 sessions, but the important thing is what is the satisfaction you want to get from this? For me, the satisfaction was getting this case that had been in court for 8 years settled. So sometimes we need to be truthful to ourselves. Why do we want to do this? If it is purely for money, believe me, sometimes you would have to take kicks that will make you unhappy in this space. For me, most of the time, it is about the satisfaction. And Oyo multi-door portals, I do most of their cases free. But the satisfaction I gain from it far outweighs the money. And it has given me, like I say, I'm a people's person. I love people. I want to make friends. I love to make friends. I love to have people around me. And some of the enduring relationships that I have today have been for people that I've helped in that manner, who have referred paid cases to me. And they'll tell me, no, we don't want you to do it under any institution. We want to come to your office, or we'll get a room. We'll go to George Hotel, get the rooms, just tell us what we want. Our orgas will not come to Lagos Multi-Door Courthouse. So if you have the ears of the orgas, you can take the mediation out of the Multi-Door Courthouse. So the George Hotel, and this is a real example I'm giving you. We did the mediation at the George Hotel. And when we finished, we took it to, because it's so circuitous. But at the end of the day, the parties were happy, they settled. And the chairman was there at the George Hotel. But the chairman was not going to go to Lagos Multi-Door Courthouse. How can they see me come to Lagos Multi-Door Courthouse when there are people sitting and I'm coming in my flowing agbada? But he will come to the George Hotel. So offer that alternative. That's why I'm saying that use what you have, be creative. And don't feel yourself, if they had come to Multi-Door Courthouse and they said, oh, we need the chairman to be here, and the chairman is not going to come here, you will promptly go to the director of Multi-Door Courthouse. Can we take this out of this space to a space where they are more comfortable? And then when we sign, we'll bring the agreement to you. It's unlikely that she will say no. It's very, very unlikely. For her, it's a plus if that big man is able to sign off. And for you, it's a plus if you're going to get. So what I'm trying to say in essence is that some of these things will come from experience. And don't keep attending this kind of platforms where you hear from different people about their experiences and how they've dealt with it. Yesterday, I got a call from a judge who has a case and wants me to handle it out of the Oyo State multi-door courthouse. I said, I'm abroad. And she called me today, oh, the parties are willing to wait, but they don't want to do the case at the multi-door courthouse. Can they come to your office? I'm not going to say no to them. I will still do it. And if I think that my office is not, I'll introduce, can we go to another space to do it? The important thing is to get it done. And done very well.
Yeah, thank you so much. Now, this next session, we like to call it the table shaking moment, where we just pick up a controversial issue, discuss it and hear your thoughts on it. And I would also crave the indulgence of Chief Bolaji in the SCN and Mr. Sheni Adio to please also lend their voice to this. Now, the theme of my next question, and I'm going to lay premises this, is mediation really justice? And I ask this because when someone feels aggrieved, probably there's been a breach of contract or something, he says, I want justice. And if we go into the etymology of justice, the definition of justice, justice is fairness. So he says, I want justice, or my right has been infringed upon. I need justice. That is why the person goes to the court of law. And more often than not, when we look at how we file the pleadings, it's direct, it's specific. I'm claiming XYZ for damages. I'm claiming XYZ, blah. It's specific. So more often than not, the judge is guided and he gets judgment for or against, direct and specific. Now, on the flip side, when we look at mediation, we say, okay, fine, can you concede to XYZ because of XYZ? Then we now bring in reality testings like, okay, fine, if you file this case in court, the court will take X number of years and all that. What we really do is to leverage, quote and unquote, on the system as a reason for why the other party should concede to something. So it now raises this question of, okay, fine, two questions actually. One, is mediation, first of all, a child of necessity to help in the backlog of cases? What is mediation really trying to do? And this is me being a devil's advocate. Is it trying to remedy, I don't want to use the word, an inefficient system? What are we really trying to achieve with mediation? Because at the end of the day, we are telling the other party to take a back seat of some sort, to concede to XYZ because of XYZ. So even though it might not necessarily look like, but at least concession based on XYZ is what we are telling the other party to do. It just brings up this question of justice. Is mediation really justice? So I'd like to hear your thoughts on this, then Chief Bolaji and Mr. Sheni Adio. The floor is yours, ma'am. Thank you.
Well, I'm going to concede the floor to the learned silks, and then I'll share my opinion. Because when you look at the word justice, sometimes we tend to see it as one thing. That one definition captures what justice is. So I'd like to defer to, I see that Chief Bolaji Ayorinde has unmuted. Perhaps he wants us to listen to him before we then listen to Mr. Sheni Adio, SAN as well. And then I'll share my thoughts.
Well, sorry, my unmuting was a mistake. So I will listen to Sheni first.
Sheni, over to you.
You know something? I already referred to Mrs. Fumi Roberts as my sis, as my mom. So now Chief Ayorinde is also chancing me and saying that he wants to listen to me first. But it's okay. He's my Egmont as well. You know, we're blood. We go back many generations.
I wonder where you're going. You're driving.
Well, you know, I'm always on the move. I'm always on the move with my turismo. Okay, but for me, Certainly, yes. Mediation certainly is justice, because at the end of the day, you don't get a resolution unless the parties agree. So to the extent at some point there's an agreement, then, obviously to me, the parties have agreed to resolve their dispute through that process, and there's an agreement and justice has been served. So that's a short answer to the question. And for me, one of the positives about mediation, in my opinion, is that oftentimes, as a result of mediating, as opposed to even arbitrating, but mediating, there's always that opportunity for the parties to have some kind of rapprochement that they can continue with their business relationship. There's no scorched earth kind of tactics. They resolve and the business relationship can continue. So I think that's a plus for mediation, that because at the end of the day, as counsel, if parties can resolve and then continue the relationship, even if it's not immediately, but at some point in future, because the relationship has not been so traumatized as a result of the dispute, that's another added value to resolving that process. So in a nutshell, I think that there's no question in my mind that if you get to resolve through mediation, justice has been served.
Oh, okay. Thank you so much, sir. Thank you so much. Yeah. Okay, Chief Bolaji, over to you, sir.
No. Okay. Thank you. First of all, litigation in itself, it's not as brutal as we tend to play it out to be. Litigation, in 90% of the cases now, you are not looking at daggers drawn and somebody must die before we leave this courtroom. When you get to a certain stage as a litigator and you are looking for the first opportunity to have the matter settled. So that's some form of mediation that kicks in. And very experienced and good judges these days will also encourage that. If there are 10 issues between the parties, if the parties can go and talk about 6, 7 issues, that reduces the workload of the judge. And while you're trying to solve, if you can solve 7 out of 10, invariably you might solve the remaining 3. So the outlook of litigation as brutal, winner takes all, may not be completely right. In fact, the current Attorney General of the United Kingdom, he said his mission this year is to make London again the capital of dispute resolution. He did not separate litigation from mediation from arbitration. He just said, look, we're losing a lot of ground to Dubai, to Singapore. We want to reestablish London as the dispute resolution capital of the world. And he was specific in saying that dispute resolution covers litigation, covers mediation, covers arbitration. And so the 3 are interwoven. For me, I welcome mediation at all times because you must get to a stage where you are able to tell your client, once there's no case you want to bring to a Mrs. Fumi Roberts or a senior deal, they look at it and they know who is trying to cheat who. Straight away, they know, right? And once you know, the skills that Mrs. Roberts talked about, those skills must kick in. You don't look at the person in the eyes and say, oh, you are the thief, right? No, you try to get the thief to, in quote, to see reason why you should not completely cheat on the other party. So for me, I see the mediation space as something that should be developed not as a completely separate mechanism for dispute resolution. In fact, mediators should find a way of getting straight into other forms of dispute resolution. The window for mediation covers every aspect of dispute resolution. So we should encourage the courts, once they find that window, send it to mediation, as they've been sending it to arbitration. So one of the ways where that mediation can really become major, and I mean very, very major, is to allow mediation to creep into the dispute resolution process. Whether people are in court, whether they're in arbitration, mediators and mediation should always be by the window, around the corner, looking into whatever is happening. Thank you.
So let us look. I'm sorry. I'm just trying to get a bit of context into this. Within the framework of what you have explained so far, sir, do you think mediation is justice or not justice?
Absolutely, mediation is justice. So as the other forms of dispute resolution, right? The point I'm trying to make is that you cannot situate mediation as finding justice vis-a-vis or compared to, in comparison to arbitration or litigation, right? You can achieve justice either through mediation or through arbitration or through litigation. You can actually attain justice by an admixture of the three. What is important is that you resolve the dispute. And our big sister, said a few minutes ago, those skills, Abby asked her about being a woman and all that. And that again reminds me of what Ruth Bader Ginsburg, the Supreme Court Justice.
RBG.
Yes, now, now of blessed memory, when she was to be confirmed by the Senate as a Justice of the Supreme Court in America, and they asked her, how would she feel being the only woman amongst all those men? And she said, look, there's no difference between a wise old woman and a wise old man. And that's basically it. So you find that concept of justice, right, in all the three forms. But most importantly, you find justice that is more acceptable to the parties in a mediation space. Because
so Chief, like, I'm going to cut you here, please. So now, is that a yes or a no?
I'm going to answer, Chief. Let me answer that question for you, because all
thank
Chief
you,
has
thank
been
you,
saying.
thank you very much.
Okay,
he has answered that question so many times in so many ways. Mediation is justice because you are giving the parties what they want.
Yep.
And you know what Chief said last is what I'm going to hinge my own intervention on. Ask yourself, is litigation justice? The same question can be asked. Is arbitration
Can I interject for a second, my big sister?
Yes, Shani, please go ahead.
First of all, I think Abby interjected because Chief was her former boss. But once a boss, always a boss. So it's not even former. But the reason I interjected is more for you to include this in your summation, which is that for example, Lagos State, the rules of civil procedure of Lagos State civil procedure rules, in many instances, part of the pre-action protocol is that parties must have explored or attempted to resolve the dispute amicably before going into court. And it seems to me that I bet that 99.9% of lawyers do not take advantage of a formal mediation process in terms of trying to adhere to that protocol. what we do is, let me use my brother as an example. I called Chief and I said, Chief, well, you know, I know normally we're together, but on this one, you know, we're opposed. So what's the deal? You know, and it seems like our clients are not interested. Okay, we've had a conversation. I do a letter to you, you respond, and then we go to court. Chief will not do that, not just as an example. That's what happens. None of us, including myself, really engage in any formal. Sometimes, to be fair, which is what I would do, I would maybe have opposing counsel come and would discuss maybe their client, and maybe that satisfies that condition. But what I'm trying to say is
Leonard Silk, sir. That is not a mediation. Calling
it's open to
opposing
debate.
counsel.
It's open to debate. No. He comes to my office and we discuss and we sit down. Why is
that is not a mediation? I would like my big sister here, Mrs. Roberts, to intervene, to interject here.
No, now, but don't say your big sister.
Because you know, I laughed. I used to work with Chief, now. And I know these conversations.
Abby, calm down. It's our big sister. Before our big sister speaks, before we went live, I was on, and I knew there was a debate between Fola and I can't remember the gentleman's name. There's a senior person on the call on this platform that they were going back and forth, and it asked a fundamental question. If you go to the dictionary, how do you define mediation? And even our big sister has said, even back in the day, a chief or an elderly person trying to mediate amongst warring parties is mediation. So query whether that phone call to opposing counsel or opposing counsel coming to my office, or in some cases may go to their office and our clients being there, having 1 hour and we can't resolve, satisfies that requirement. I think it does probably. What I'm just trying to say is that there's room for us going beyond that, of even attempting to have a formal mediation process, such that if we then resolve, fine. If we don't, then we go to court. But I don't think most of us are taking advantage of this mechanism of mediation in terms of the formal process to actually resolve issues before we go into court. And my final point that I would make is that at the time I first came back to start practicing in Nigeria after many years in the US, I found that when I tried to be sort of conciliatory or what have you, a lot of lawyers here see it as being weak. That's the psychology of most lawyers in Nigeria. And most lawyers in Nigeria, when they write you letters, they're very bombastic. So even you think, well, if you think I'm going to be weak, or I'm weak, or I don't believe in my case, by writing a letter that is conciliatory, that we try and resolve to you, then, hey, let's go.
Let's go. Okay.
Now, before let me just throw something in from what Mr. Joe has said. I think it also, maybe it's part of our responsibility as promoters of the mediation space to also engage, let's say, the Chief Judge of Lagos State and say that, look, listen, but just filing a document to say, oh, we've tried to resolve and we couldn't resolve as part of the pre-action protocol, and that, you know, the court should take that further and say, no, I would like to see a report from a mediator, right? So if the rules can be, you know, interpreted in that way, I mean, so if I'm a judge and I hope I'm qualified to be one, I can look at these papers and say, oh, you've written here as part of your pre-action protocol that you and Chief Ayoride, you've both discussed on the phone. I said, this is bad of people. Okay, please go back. let me have in the next 3 weeks or 4 weeks a report from a mediator. Then mediators are in business. If that should happen, you know, and actually counsel can actually challenge and say, no, if you called me once or you wrote a letter to me, I wrote back to you, that does not satisfy the provisions and the spirit of the law. So send us back for 4 weeks. Then we come back with a report from a mediator to say, we've been able to resolve, we've not been able to resolve. And that will help the mediation process, I think. So,
okay.
Yeah.
Thank you so much, Chief. So, Mr. Roberts, a lot has been said.
Yes.
Over to you, man.
There's so much that has been said. It was such a rich conversation. I could pick about 10 issues I want to talk about. And I'm so glad about the intervention of the learned selves. I was about to ask a question, but I will take off from where Chief I already spoke last. Because the pre-action protocol Mr. Chinwe Adio, SN, was talking about is different from mediation. The pre-action protocol didn't say go for mediation. It just says the parties should try to settle. And that is why a phone call would suffice. So perhaps we need to be listening to the kind of suggestion Chief Ayoride has made, that perhaps it is now known, it's not about you attempting to settle, but showing evidence that you actually participated in a formal mediation process, which is what London is trying to do now.
Yeah.
Is trying to make it mandatory. And they are having so many conversations about it even as we speak. But I asked a question, is litigation justice? Is arbitration justice? You know, when we ask that question of mediation, I laugh. Because in mediation and in arbitration and litigation, it is the judge who decides who wins and who loses. And more often than not, the person you perceive as the wrong person may win. And I'll share what I do in my arbitrations with you. At my first preliminary meeting, my agenda always includes a line that asks for permission of the parties whether I could act quo bono. I can't remember it exactly as it is in the Arbitration and Conciliation Act. But what that provision of the law says is that you as an arbitrator cannot act in the interest of justice without the permission of the parties. That is, that phrase, e quo bono, means in the interest of justice. So I always put it on my agenda that can you give me permission to act in the interest of justice? Not on one occasion have counsel and the parties picked me up on that. They always say, no, we want you to go according to the terms of the contract, the agreement, and so on and so forth. But I have read the synopsis they sent to me. When I go for pre-hearing review, I still ask the parties, are you sure you want us to have this hearing? Can you give me permission to deal with this on the basis of the interest of justice? Counsel, I have not seen a single counsel take it up. I have read the pleadings. I can see that there is no way, no matter how right the claimant or the counter-claimant is, there is no way he's going to get the kind of justice he anticipates he would get, because due process has not been followed even by him.
Sorry, you don't lose that flow of thought.
Can I just finish? Okay. You see, due process has not been finished by him. But if you are telling me go by the strict letters of the law, he's not going to get what he wants. So have I delivered justice in that context? And then what does justice mean to you? You are in a mediation, and all one of the parties wants is an apology. And he gets that apology and it diffuses the entire. I've had somebody tell me that, look, I'm only in court because this young man is my son and he's rude to me because of so and so, and he went on and on and on. And I said, sir, so apology is important to you. He said, yes, Mrs. Roberts, it is very, very important to me. It took a long time for me to convince that billionaire young man that, hey, this is your father. In the end, he apologized and we settled that day. For the old man, justice was getting that apology. This young man, I was the one who named him when they were naming him. How can he, because he's now rich and I'm one of the executors of his father's will, and he thinks he can do this and this. So what justice means is relative. And believe me, I see parties get more of what they want from taking the chances of going to litigation, the whole hog, and not getting anything at all. Because that's one of the reality testing you are going to be telling them. What are your chances of winning? Are you sure you are going to win? And in my law firm, for example, I will not, in fact, if you are a counsel in my law firm and you tell a client that we are going to win this case, I'm going to sack you. I will have no hesitation in telling you to go because you have no business giving an assurance of something you have no control over. But in mediation, the parties are in control. They are the ones who determines what justice means to them. You are not forcing them. You are not forcing anything on them. It is for them to determine what they want. And then yours is to steer them along the way to ensure that they get what they want. They get the kind of justice that they want, and not Mrs. Roberts' perception of what that justice means, or the judge's perception of what that justice means, or the arbitrator's perception of what that justice should be.
So, if I understand it clearly, are you saying that first of all, the concept of justice is subjective? Would I be right to say that within the context of what you have said? That's number one.
Fola, as if you put on a hat of a mediator, you have to see justice as being subjective. Okay, that's number one.
Then number two, are you now saying that if we look at the concept of justice within the scope of mediation, is it different from the scope of justice in litigation? Why I ask this, is this? Because this is taking us deeper into the concept of burden of proof. If we look at the burden of proof in a civil matter, they say preponderance of evidence. If we look at criminal, they say beyond reasonable doubt. Now, there are certain elements. Okay, hello. Is it better now?
Let me put off. Maybe it's me. Let me just.
Yes.
Okay. Please go on.
Okay. Yes. Now, I say if we look at the concept of burden of proof in any civil matter, they say it's a preponderance of evidence. We look at a criminal matter, they say beyond reasonable doubt. More often than not, on any tortious topic, there are certain elements that make up maybe negligence, make up tortious liability and whatnot. So the only what I'm just struggling with now, vis-a-vis this concept of justice and mediation, is the act of concession, which, because we keep saying that, okay, fine, mediation is justice, mediation is justice. Mediators must be seen to be neutral. But then again, there's always that balance, that concept of what we think is right and what we think is wrong. So if at the end of the day, we are now saying that because parties have agreed on something, I'll use a pedestrian example. A is owing B 1 million naira because B has said, okay, fine, all I want is an apology. So within the scope of that, we say that is justice. If we not put into play the power imbalance and all of that. So I'm just trying to really understand that concept.
You see, this is not something that bears of one answer. You cannot give a single answer to this conversation, this recent conversation. And I still am very, very much of the opinion that justice cannot be, if you are telling me that a judge has deprived me of my land because a land I bought 20 years ago, but they said I've not been in possession. So the great-grandchildren of the person who sold it to me can come and still claim that land. And they said because I would lose it because I did not fence it. So statute of limitation does not help me. I did not do anything that stamps my ownership on the land. And I'm talking about a real life mediation that I did. They said, look, hey, okay, you bought the land 18 years ago, but you didn't do anything about it. All you have is a survey plan and the agreement signed by, but these men are dead. The grandchildren now came up and said that, no, the wrong party sold it. It was very clear.
Only 1K. Only 1K.
Mr. Benjamin Fatogun.
3K.
Yes. It was so clear that the claimant was going to lose that. And the judge referred them to mediation, and the judge insisted that I should be the one to do the mediation. At the end of the day, we were able to settle. The guy just paid them a little amount of money, but he still had his land. Left to him, he would not have wanted to pay at all. So the concession he made was to pay them 2 million just to give him back his prime land. Okay, that is a concession. Are we saying that because he made that concession, there's no justice when he still retained his land, the value of which is several times over and above the 2 million he paid to settle the land grabbers? I don't know whether you understand. That's why I'm saying that you cannot box justice and give it one meaning and say that it applies for all purposes. No. No. You go to court at times and you come out and you are weeping. I can give you an instance. A gentleman, long story short, was going to take a daughter that the mother had run away with from his house. Very, very dirty story. But we knew that if that girl had stayed with the father, he was going to abuse. What did the council do? The council went to the native court, got a court, man should not take the girl from the mother. The father went to court, and the court said that the native court didn't have jurisdiction over the matter. So the woman should return the daughter to the man. Of course, the next day, the woman and the child flew out of the country to run away. What justice did they get in the court? When you want to return this girl to an abusive relationship, simply because the order you got from the native court was set aside on jurisdictional ground. Is that justice? So the point I'm making is we don't let us look at justice as one definition fits all. What I consider justice of a situation will be different from what would happen in a different circumstance. If it is the woman who is being abusive and the man wins, of course, promptly, FIDA will go and get the guilt of her mother and give to the man, because that is what will serve the justice of that situation at that particular point in time. And for me, that is what mediation seeks to do. Nobody is going to force a party to concede if he doesn't want to concede. Even for evaluative mediation, you can't. Because evaluative mediation is just enabling the parties to give informed consent to their settlement. But facilitative is you guiding the parties and staying off the matter entirely, which sometimes can be plastic and unnatural. So what I'm saying in essence is that when we talk about justice and we go into the jurisprudence and so on, that is not what the man, your client, the parties want. They don't care about jurisprudence. All I want is that this man is owing me, but because he's a multinational and can afford the big lawyers, and he knows that I cannot, he's trying to cheat me. Can you please help me to get, even if he's not going to give me the 10 million, let him pay me 8 million. Let him pay me 4 million. So it's not a total loss. When the multinational can tie him up in court all the way to the Supreme Court, is that justice? So when you ask that, is mediation trying to remedy a bad situation? Why not? And don't forget, I don't know whether Chief Ayoride and Mr. Sheniaji would agree with this data. More than 60% of cases that are in court eventually settle out of court, whether through mediation or not. More than 60% of them eventually settle in one way or the other. So whether it is a way of remedying a difficult or deficient system, The important thing is that that system needs to be fixed. And when you're looking at it, you have to look at it from a global platform. This is not a conversation we are having in Africa or Nigeria alone. It's a global conversation. The merits of mediation is a global conversation now. And if everybody is jumping on it, are they jumping on it because they are in an inefficient system? No. I don't think so. If England, I mean, if you look at Queen Mary's study on arbitral institutions, UK, London is one of the best seats for arbitration. Singapore is one of the best seats, but that doesn't stop them from continuing to promote mediation. Because even in that space, mediation has a role to play. I don't know whether that has helped. But
okay, yeah, it's put things in proper perspective. Yes, it has. So, Abby, over to you, so I can finish my segment. Yes.
Okay, great. I'm sure that I still have so many questions to ask, but we have to be conscious of time. Thank you so much for this. Thank you, thank you, thank you. I'm sure there are people who have divergent views from what you've said, but I mean, the light is shining brighter on it now. Thank you so much. So I want to ask, like, where do you see mediation in the next couple of years? In the not too distant future?
If you had asked me that question 15 years ago, I would have said that, well, I don't know. But believe me, the young lawyers that we have in the universities are not prepared to do litigation for 20 years. And that is why you have, like I said, there is hardly any, the likes of Mr. Shenia and you are going to leave the center stage. The likes of Chibola and Ayori, they are going to leave center stage. And these are young people who don't care whether you give them silk or not. All they want to do is move on with the cases. They don't care. Not everybody wants to be silk. Because some of the cases that go on and on is because we are all in this profession. We know what it is about.
We are not that old.
I'm
not saying no. I'm just saying we're not that old.
So that they can add it to their dockets. The young people coming on board have formed ADR societies because of the faith they have in it. I don't know of any university in Nigeria today that does not have an ADR society. And you are talking to them and they are saying that we don't have the time to waste on all this going to court and being in court for so many years. So believe me, litigation will have its place because it's a constitutional right for you to go for litigation. But the way even mediation is going to be practiced is going to evolve. And when you are worried about the fees that you are being paid, or it's not the same fees as arbitration. You know what one young man said one day? He said, Mrs. Roberts, I would rather have 10 mediations paying me 100,000 and I finish the 10, have a fantastic track record, I've formed fantastic relationships with 10 people, than taking one case to court for 10 years to earn 1 million. That spoke volumes. That's their mindset. That's why I'm saying that if we had had the benefit of being taught about mediation and all these ADR processes when we were in school, maybe our thinking would have been different. Maybe it would have not been as difficult to introduce mediation to our community here. But that was not the way we were. So we had to relearn the process.
If I may just add an overlay to what Mrs. Roberts has said, I think just about all the courts now, just about all of them, Federal High Court, Court of Appeal, so even Supreme Court, they have practice directions now that provide for mediation even at the Supreme Court. So I think that really sort of accentuates the fact that it's the way of the future.
Thank you, Leonard Silk. Thank you so much.
Thank you very much, Leonard Silk.
There's a hand up, Benga Bello.
So, Mr. Ben, can you make it very short?
Succinct?
Yeah, because we already spent more time.
Very succinct, very
so I can finish by 7.
Points.
Thank you so much.
Yeah.
Thank you very much. This is Robert. Leonard Silk. It's been wonderful conversation. For somebody like me who has been a litigator virtually all my practice life, and now that I'm back in house, it's fantastic to see how much consideration I given, looking at the concept of justice, the concept of mediation and arbitration and litigation. Listen to Mrs. Roberts, and I agree virtually with most of the things she said. Because sitting as an in-house counsel and looking at my business, I think the first consideration for me is what do I advise my business when I am faced with a issue? And a lot of considerations come into play. First, is the fact that, look, is this a relationship I want to serve? There is three issues that I need to put my foot over for the benefit of my country. Because that, for example, you have, I am in telecom system, and you have a local government or a state government, coming into my state. What telecom is actually in the exclusive sphere of federal regulation. So you find that there are certain things you will not take into consideration because you want a straight decision backed up with the force. I agree with certain things. For example, I had a long conversation of mediation, so to speak, because you find out that as in-house counsel, what we do is to keep a balance in what the dispute presents at the end of the day in terms of what is the benefit to my company. Would my company be beneficial? Would my decision to go to court, for example, be beneficial if I'm in court for 20 years? Sometimes it's more strategic, in view of the dispute that is thrown at me. But I agree that these days I found out that most of us are looking in what is the mediation phase, particularly now that most of the court-assisted mediation is the leeway to look more.
Sabat. I said succinctly. I said be succinct, Sabat.
It's been very enjoyable. Thank you very much, Viola.
Unfortunately, I couldn't hear most of what he said. Viola, is this something you can summarize? Because I didn't hear the question at all. I mean, the audio wasn't very clear at my end.
I was actually going to say that myself. That it wasn't really clear. But I think basically what he was saying was that he's been in litigation all his life, and now he's back in in-house as an in-house counsel, and he's very glad to be in this conversation and the possibilities of mediation. That was the little I could make out. But I know him, so I can actually reach out to him.
He also said that as in-house counsel, he has to weigh circumstances where it's important to preserve the relationship between his employer and the adversary.
Okay, thank you so much, Leonard Silk. It seems as if the Leonard Silk would be good, Fala, to have the Leonard Silk on this program soon. Yes,
and that will be at no charge.
Yes, ma.
And what Benga said is true. There are times you have to go to court because you need a policy pronouncement. You need a precedent. And in that instance, particularly if you're dealing with state governments, sitting with Oyo state government and agreeing something doesn't mean you can take that to Ekiti state government. It doesn't mean you can take that to, so depending on the business you are in, there are certain cases that you need to set on the pedestal of precedent. I quite get that. And it's just the same with arbitration. Not every matter is arbitrable. We've had pronouncement that tax matters are not arbitrable. So perhaps there are some instances where you must necessarily make that journey through the court process. Absolutely.
Okay.
Thank you so much, ma. Thank you so much. Okay, go ahead.
So yes, ma. So in rounding up, ma, we have a bit time.
Go ahead, Fola. That's fine.
Okay, yeah. In rounding up, we have a cross section of lawyers, mediators, end users, and then people that are curious about mediation. What final words do you have for them on mediation and just and everything generally, Tospama? So, what are your final words to everyone listening to you right now as we conclude?
Well, first of all, if this is my closing, I'd like to thank you for the opportunity to be here.
Thank you so much.
It's something that I've always wanted to do, but like my children always say, Mom, you'd always find time to you'd always find time for what is important to you. Mediation is important to me. So is arbitration, and for different reasons. And what I would like to say is that don't be discouraged, but first of all, determine why are you in this space? Why are you in the mediation space? If you're in the mediation space to make money alone, perhaps it's not the best space for you, because you're going to be hearing what the arbitrators are earning, and it is going to make you dampen your spirit. But Chief Ayorinde has said something which I want you all to hold on to. You don't have to wear the cap of a mediator only. You can be a mediator and be an arbitrator. I am both. I'm also into expert determination and adjudication for construction cases. That's why I'm a member of Guild of Adjudicators in Nigeria. It's an organization we just founded. Adjudication is like close to arbitration, but not quite the same. So that is why I call myself an ADR expert without necessarily saying that, well, I'm a mediator alone or I'm an arbitrator alone. You can wear those hats, but the important thing is make sure that you are qualified and you've tooled yourself to be qualified. As adjudicator, I had to go to Dubai for a 5-day course. And it cost me a lot of money to go for that course. But I know that it's a space I wanted to operate in. So don't box yourself into mediation alone. Spread your tentacles to other dispute resolution mechanisms. And finally, if there's any way I can help you, please reach out to me. Thank you.
Yeah. Thank
Please,
you
I'm
so
first in line, ma.
much.
You remember from last summer, I'm first in line. Anybody else, you remember me? Just saying.
Yeah. Thank you so much, Mrs. Roberts. And one thing I want to say is Mrs. Roberts is actually very passionate about young lawyers and people desirous of getting into the business and practice of mediation and ADR. So thank you everyone for tuning in. It's been an amazing session, and we look forward to having everybody here with us. Mrs. Fumi Roberts, Chibolaja Yorinde SCN, Mr. Sheni Adio SCN, and every other person that tuned in. Thank you so very much, and we wish everyone a beautiful weekend, and we look forward to seeing you. I don't know whether it's next week or upper week, but I know on August 28th, we'll be having Honorable Justice Wole Harriman to really hear about mediation on the bench.
Excellent.
Yes, she'll be here with us on August 28th. So we're going to really look at mediation from the perspective of a sitting judge to hear what she has to say. Thank you, everyone, for tuning in. Mrs. Roberts, thank you so much.
Thank you very much.
So
really
much, Auntie.
Thank
you, Mrs.
Thank you,
Roberts.
everyone.
Thank you.
And I wish everyone.
Day. I'm always loyal, sir. Thank you. Thank you.
Okay, thank you so much.
Mrs.
Thank you, everyone.
We appreciate you.
Thank you so much.
Thank
you for attending. I can see those now. Thank you, thank you, Tokumo, for being here. Thank you.
Thank you so much, everyone. And for those that tuned in a bit later, the recording is on YouTube. Yeah, kindly search for Fortify Mediation Academy, subscribe, and you can watch this video and other videos that have been posted. Thank you, everyone, and enjoy the weekend.
I think between you and I, we're going to ask Leonard Silk to make time for us, so that we can have him on the.
Yes, we will. We'll have a private discussion with him on this. Thank you so much for being here.
Okay. Thank you all. Thank you so much.
Thank you, everyone. Bye.